Welcome to Learn Laws.
Welcome to Learn Laws. My name is James White, and we're here with Andrew Easler. And today we're going to be talking about LLC operating agreements, right? So, what exactly, Andrew, is an LLC operating agreement, and who needs one?
Okay, let's start with what is an LLC
Sure.
before we get into the nitty gritty of the operating agreement. An LLC is a limited liability company. What that really means is it's a hybrid between a partnership and a corporation, right? The corporation gives you a great deal of asset protection because it creates this new corporate entity that will shield you from some kind of liability as long as you don't break the rules too much.
Okay.
Okay. And the other benefit of a partnership, which is a lot of flexibility, adaptability on how you govern and operate the business. So it's a newer hybrid that's very popular because it doesn't have the same level of high standard for corporate compliance. You don't have to keep up with the minute book as aggressively as you do a corporation.
Perfect. So, an LLC is usually used for smaller businesses that are starting up that don't need to raise money, correct? So, if I'm raising money, then unless I want members, it's more advantageous to obviously most people that raise a lot of money do it like in a corporation or some sort of other business entity. Are LLCs more geared towards smaller businesses?
Well, actually, that's an interesting point you make because there's quite a few of the largest companies in the world that have converted from corporations to LLCs,
Oh,
including Google out of Delaware.
Oh, wow. That's very, very interesting. So, why would somebody need an operating agreement? So, I form an LLC. I assume that, it's done at the Secretary of State. Once I have my articles of organization, I'm good to go. So, a lot of individuals that I speak with, a lot of other entrepreneurs, I ask them this question just preparing for the show. Do you have an operating agreement? And if so, how did you structure it? And I would say 5 out of 10 people, 50% said they've never had an operating agreement before, and they didn't even know what it was. So I was very shocked,
Right.
and that's where I came up with the idea for this show. Is let's explain what they are and why they're so important, and actually why you should always have one, even though they're not required. You're not required to have one. It's important to have one.
Right. So, for example, in the state of Florida, to start your LLC, all you need to do is file an articles of organization with the Secretary of State, and you're off to the races. The problem is that's just going to give you the skeletal framework, right? You're just giving them the name, your principal address, your mailing address, who your registered agent is, and then who's authorized to bind the company, right?
Perfect.
That's it. So the public knows now that there's this business that's out there that exists. But as to the internal operations, what's going on? How do your muscles move, metaphorically speaking, right?
Yeah.
That's where the operating agreement comes into play.
So I think that's where the biggest confusion comes in from somebody that is starting an LLC is because they go on like a Secretary of State's website and they say, "Oh, I can file." I think Florida it's like $200 or $140 or something like that. It's not super expensive. So they go online and they don't realize that they need an operating agreement. They don't realize why they should hire an attorney. So when you hire an attorney to help you, not only do they form the LLC properly according to your wishes and your future goals and medium and short term goals as well, but they also help you prepare the operating agreement because it's like a small business plan essentially. When you start, it's like a miniature business plan, and that's the way I've always looked at operating agreements since I've started learning more about them and understand them a lot more. I feel like they're like the miniature business plan before you create like the real business plan.
Yeah, and I'm glad you brought that up because even people that have done that and then come to the attorney afterwards, you may find out that you chose the wrong entity type. Right?
Yeah.
It's not right for everybody, the LLC, but it's also corporations are not right for everybody. And I've
Correct.
had people come to me, hey, I just formed this new corporation. Here's what I want to do. Why did you choose corporation?
Yeah.
Oh, well, I thought that was what it was. I came from Canada, where
Yes.
that's
Well,
the
that
most
happened to me.
common.
That's a perfect
right?
example. That's what happened to me, right? When I first moved to Florida, I was forming inks all day long, and I didn't realize the actual benefits of an LLC because I didn't have that legal knowledge. And
Right.
that's why we're doing this show is because there's so many people out there that either want to start a business or already have a business and they just don't know, right? They don't know the different types of corporate structures that exist, which one's right for them. So I think a lot of people become very intimidated.
Right.
And that's why they don't do an LLC operating agreement because they do the first part and then they say, well, I'm so intimidated because I don't know what needs to be in there. I don't know if it's legal, if it's not legal. And this is why it's important to obviously consult an attorney for personalized legal advice. But
Right.
it's also why you need an LLC operating agreement, because this helps you think through these things. So if you're asking questions like, hey, is this legal? Can I do this? Can I do that? Well, when you start thinking about an operating agreement, when using an attorney, then you'll get answers to those questions, but you'll be able to improve on that corporate structure.
Right.
Correct?
100%.
Yeah.
Because the attorney's going to ask you questions and bring up things you probably never even
Yep.
thought about.
Yep. You do
Right.
that all the time with me when I ask you questions. So,
Right. So the entrepreneur's job is to see all the good things that are going to happen in the
Yeah.
future, right?
Yeah.
You got to have sunshine and rainbows to believe in the business enough to
Correct.
put money in it,
correct.
right?
Correct.
But when you come to an attorney, our job as a business attorney or as business structuring attorney is to think about strategy, think about the worst possible case scenarios,
Yeah.
and then talk to you about, hey, how do you want to handle that scenario should it happen in the future? And of course, you're going to say, well, that's never going to happen. I'm never going to have a business partner that's going to be starting to embezzle funds from me or not do
Yes.
this or
It
do
happens all
that.
the time. It happens all the time.
Right.
It's really crazy how the world has changed so much. So, and I think the other reason why people get confused about LLC operating agreements is because it's not required, if I'm correct, you can correct me if I'm wrong, it's not required to be filed with the state.
Correct. Yeah,
In Florida
that's
specifically, but other states might have different requirements. I'm just talking
Mhm.
about my experience in Florida. So when you file your articles of organization, if you're doing it yourself, for instance, or you're hiring an attorney, the attorney would obviously know this. But if you're doing it yourself, you don't know that you need an operating agreement. You might not even know that an operating agreement even exists because there's no requirement to
right.
upload it. There's nothing there. So I think a lot of people get confused. So it's not required to be filed with the state, but you should have one anyways.
Right. And this is something you probably don't want anybody in the public seeing, right? Because this is really just a contract between yourself, if you're
Yeah.
a sole member of an
Yep.
LLC,
Yep.
or yourself and your members, right? The other people that have started this business with you. How do you govern that relationship,
And
right?
that would be a multi-member LLC, right? So you'd have
Mhm.
a single member, or if you
Yeah,
just
sole
you
member LLC is what we often use
and a
as a term,
multi-member
and a
LLC.
multi-member
So when
LLC.
somebody has like business partners or a certain type of ownership structure, that would be classified as a multi-member LLC.
Mhm.
Okay, perfect. Okay, I just wanted to clarify that.
Yeah. So if you don't have an operating agreement and you start this business and you've got other members that are a part of it, and you have a dispute, then the dispute is governed by your state statute, right? You guys don't get to choose how to interpret that relationship unless you have proof or you agree that you have already verbally agreed in the past, which is sometimes difficult to prove. And if there's a dispute, that's usually because somebody misremembers or remembers it differently than you remember
Correct.
how things were supposed
They
to
have
happen.
their own truth, right?
Yeah.
Yes.
Right. That's why we reduce things to writing as
Yes.
attorneys.
Yes, so you understand everybody's on the same page, and if there are disagreements and arguments, then you can either the partners themselves, or if they have to get attorneys involved, educate each partner or educate each other on what they actually agreed to.
Right. That's one of the really
Yeah.
important parts of when you're starting your business,
Yeah.
right? Go to an attorney after you've had a little bit of a conversation with people that you want to start the business with,
Yeah.
right? Just feel them out first, right? How do we want to run this business? Who's going to be in charge? How much money are we going to take out? Do you need a salary? Do you not need a salary? How much money are we going to be putting in? How much am I going to be putting in? How much are you going to be putting in? Are your connections going to be able to be leveraged? Because I know that you have these connections with other people.
Yeah.
Or are you just going to say, no, I'm not going to leverage those connections. And now I have a misunderstanding of what that relationship's going to be or the value that you're going to provide to this business.
Correct. So one of the main, I think the most important aspects of an operating agreement is it actually defines or clarifies ownership structure
Right.
and ownership contributions, right? So it defines ownership and then the contributions of the people in the LLC, because there's member managers, which is like,
Mhm.
the owner manager, and then there's just members that, own a portion of that LLC or a membership interest in that LLC. Am I correct?
Yeah, yeah. And by default, if you don't have an operating agreement, then the state has to guess as to what your intentions were,
And
right?
that's not good. You never
That's
want to let the state
not
guess
good.
what your intentions are,
Right.
right?
So we
Yeah.
just presume, for example, that if you start a business with me
Yeah.
and we both go on
Yeah.
the articles of organization as authorized members, that is 50-50. But we could have had a verbal agreement that it was going to be 95-5 because you were going to put in $100,000 in equity and I'm just going to be out there using my name.
And that's what an operating agreement resolves, those kind of ownership issues that could potentially turn into disputes later on.
Correct.
Right? Okay, perfect. Okay, awesome. Yep.
Yeah, I mean that's one of the great benefits, but
Yep.
I mean there's a plethora of other benefits. So I want to get into one of them right now, which
Sure.
is holding your ownership structure. We talked about apportioning equity, but also, let's say you're married, right?
Yep.
Husband and wife, and you guys start a business together,
Yep.
right? If you have an operating agreement in 26 out of 50 states, you can hold that interest as tenants by the entirety. Have you ever heard of that term?
No, go ahead and explain that for me.
So tenants by the entirety, this is a vestige from the Victorian era,
Okay.
right? And it's also part of our Christian roots where, basically a man would marry a woman and she would cease to be a separate legal entity. And, suffrage people and feminists, please don't freak out, right? We've obviously gone through suffrage and women's
Yes.
have
Yes.
gotten a lot more rights. But the idea is that the husband and the wife both contribute
Yeah.
to this particular structure together, and then
yeah.
it becomes a marital asset,
Ah, okay.
right? And now the marriage itself is what owns this particular asset,
That
and
makes
you can
sense.
basically hold your LLC membership interest as John and Jane as husband and wife or as tenants by the entirety.
Oh, wow.
And with that, you get a great deal of benefit. Number one, you get a right of survivorship
Yeah.
between the interest, right? So if one of them were to pass away, the other would automatically succeed to the interest
Oh,
and
wow.
avoid probate,
That's incredible.
right?
Yeah.
Number two, the better thing is asset protection. So if Jane gets into a car accident and gets a judgment against her, and that creditor comes out looking for what she owns to try and take things, if all she ever owned is stuff that's owned by the marriage, they're probably not going to be able to go after it.
Wow. So I guess that's why, like, from a real estate developing perspective, why I put my properties into an LLC, because if somebody sues you, they can get a charging order against you essentially, but they can't technically or theoretically take that asset.
Yeah, so whether or not they're granted a charging order, it also depends on whether you're a sole member or a multi-member LLC.
Okay, got you.
Right?
Okay.
So sole member is pretty easy for a creditor to just go in and start taking assets because they're just going to treat that entity as a disregarded entity when they're coming from the backside, from the reverse,
okay.
coming
Perfect.
you personally as the member and going after what you own.
Okay.
Okay.
That makes sense.
Now, but if you own that with me and I'm the other member, I'm going to say hands off, right? That's not fair to me. I don't owe you anything, buddy.
Yeah.
Right? To that
makes sense.
creditor. So you can't come and take the underlying asset from
Yeah.
my expectation, right?
Yeah.
I have an investment backed expectation that
Yeah.
that money and that asset and that real estate, whatever it is that they're trying to take, is going to be out there working for me.
Oh, that's very interesting. So that's why that one aspect, and it's just incredible how one legal concept can change the whole outcome of somebody's, small business. I mean, it's truly
Right.
incredible, right?
And the other interesting
Yeah.
thing is, right, if you're listening to this podcast,
Yeah.
I'm talking about Florida.
Yes.
Right? Florida recognizes that as a legal concept, and they say it wouldn't be fair to this other member, but some other states don't.
Yeah.
Right? So, just keep an eye. That's another important aspect of knowing why to talk to an attorney.
Yeah.
Right? Because you don't want to be, oh yeah, I've listened to this podcast and I'm in Alabama.
Yeah.
Right? And I'm
Yeah.
going to trust all this information this guy's telling me, and I'm just going to go out and do it myself.
Yeah, don't do it yourself. One of the biggest pieces and the most important pieces of business advice I give everybody that I speak with or I consult with is always hire an attorney. I've never understood why. Look, I think I do understand why to a certain degree, but I've never understood why, if you're going to start a business, you're going to do stuff yourself, especially when it comes to a legal perspective. Look, if you're your own attorney, okay, I get why you're doing your own LLC because you know the rules, you're educated, you've gone to school for, XXX years, so you should, know what you're doing. But a lot of people that start, they just don't want to pay the money to hire an attorney to do it right. And I think that is the biggest mistake that anybody can make. Whenever, again, whether it's an operating agreement, business contract, service contract, whatever the case is, you can, put your ideas down on paper, but always make sure it's reviewed by the attorney. And there's a lot of benefits to that. And we'll get into that with the LLC operating agreement later, with malpractice insurance. But that's something that I have to reiterate, because a lot of people just don't understand why you should hire an attorney for an LLC formation, and specifically why you should always hire an attorney and not one of these online do-it-yourself websites for this particular this particular reason, right? Whether it's asset protection, whether it's ownership structures, whether it's, you know, verifying that who owns what. I mean, there's so many important details that go into an operating agreement that it bedazzles me that people just don't understand why they need an attorney.
Right. I mean, there's a lot of really important pain points,
Yeah.
right, that
Yeah.
end up happening, right, when you after you start a business with a buddy,
Yeah.
right, and let's say it's losing money,
Yeah.
right? What does your operating agreement say about whether that other person should be putting more money in, or whether you should be putting more money in,
So there's
right?
there's no
If you don't have
rules.
an initial capital commitment where you and your buddy have agreed in writing on how much more to move on, how do you resolve that dispute, right?
So question for you, how would you resolve, in theory, right? How would you resolve a dispute where somebody didn't have an operating agreement? They each put in $10,000 as a startup,
Mhm.
and then they need more money. And one partner wants to put money in because they believe in the business. And the other partner is a little nervous, you know, just wants to, you know, go get a job and be done with it. How would that dispute generally play out in Florida?
So, well, there's what's on paper, and
Yep.
then what happens in reality. Okay.
Yeah.
So on paper, you would have to go to litigation, right? If you have a dispute with your business partner, and the business partner wants to do one thing, and you want to do a different thing, you can have a
Yeah.
vote on the issue, and if you don't agree, if you're 50-50, then you have a stalemate, right?
Correct.
And so if you're stuck in this business now and you want to be out, right, then you have to maybe partition your interest, which is a whole
Ah.
course of litigation. It's very expensive, and costly, and you have to get permission from the court to sever your interest.
Oh, wow. So that's
Okay.
another episode. We could talk for 8, 10, 20 hours on that
Right.
side of it.
Absolutely.
Yeah.
So that's on paper how it would work if you could never come to some kind of solution. In practice, often once people realize that that's really the
Yeah.
only other solution at that point, they begrudgingly agree to something that maybe they wouldn't have had they had an operating agreement that defined those roles and
Like selling their
responsibilities.
interest back to the other partner, or, you know, just
Yeah. Or
becoming
you could
more of
hold
a-
them accountable. Let's say,
Yeah.
hey, I commit to starting this business. We
Yeah.
need 20,000 to start, but we know we're going to probably need another 100,000. Maybe we're going to buy some brand new equipment.
Yeah.
Okay. And we know that's on the horizon. So we say, hey, listen, if we end up needing that money because our initial capital contribution has not made us enough money to buy that $100,000 piece of equipment, we both agree that we're going to put in an additional $50,000 if we have to.
That's interesting. So an LLC operating agreement, it proves the business structure, meaning the ownership structure,
Right.
who's like the member manager, who's
How
just
they
a
hold
member.
that membership interest,
How they hold that
like tenants
membership.
by the entirety.
Okay, that makes a lot of sense. And then it also, in practice and in theory, I guess by having all that in writing, it would prevent a lot of partnership disasters, like you were talking about, where there's contribution disputes, there's, you know, roles and responsibility disputes that could just not only destroy friendships and partnerships, but destroy businesses too, and what they were intended to accomplish.
Right. Yeah. I mean, this is why you want to sort it out right here in the beginning.
Yeah.
And if you guys can't agree on this now,
Yeah.
you don't want to be, 500 grand into this thing, right? And operating a business long term, and maybe you really believe in it, and then all of a sudden realize that, the other side had a completely different apprehension
And
about
this
what
happens.
the relationship was supposed to
And
be.
this happens all the time, even when I'm hired as a business consultant to go in there and help build people's businesses or help them start a business. This happens a lot more than people realize, and there's so much money lost, and there's so many friendships and goodwill lost that have taken 20 years to build,
Right.
and then it just blows up in everybody's face. So that's why I think an LLC operating agreement is always important to do sooner than later, because it not only proves that it's separate from you in the ownership structure, it is sort of like a small business plan and allows for custom rules. So you can do like kind of almost whatever you want as long as it falls within the legal, framework of that specific state. And it also prevents partnership disputes, which I think is super important. That's why I mentioned it again, because I think that's super important, because if you have partnership disputes, you're not going to be able to have a good business.
Well, I mean, there's always going to be a dispute down the road, right?
Yeah.
Everybody has their own ideas about how they want to run things and what's the best for things. It's important, number one, I think, just as a general mantra that you and I like to utilize, is stay in your lane.
Yep.
Right.
Yep.
But you have to identify
Yeah.
where those lanes are
Sure.
from the outset, right?
Sure.
Hey, I'm really good at finance. You're really good at the legal aspect. You're really good at sales. I'm really good at marketing, right? You define those kinds of roles, and that helps kind of resolve who's
Yeah.
supposed to be making those kinds of
Yeah.
decisions, right? Oh,
Yeah.
I'm the marketing guy, so I'm going to approve every direct mail piece that's going to go out,
Yep.
right? And then maybe you're the finance guy,
Yep.
and you're going to say, okay, well, you want to spend $50,000 on this direct mail campaign. You can approve the design, but I'm going to, only approve $25,000 for this campaign to make sure it's going to work for us.
Ah, okay. That makes a lot of
Right.
sense. So question for you. If you don't have, and I know with an incorporation, because you have so many corporate responsibilities, that it's called the corporate veil.
Mhm.
So can you explain to me, the question I'm going to have, and I'll ask you it now, is if you don't have an LLC operating agreement, can the court system pierce the corporate veil um, in the event of a partnership dispute or some other dispute, whether it's with an outside creditor or a partner? And again, that's if you don't have an LLC operating agreement.
Okay, yeah, that's a great question. So, when the court is looking at piercing the corporate veil, and that's whether it's a corporation, an LLC, partnership, that kind of
Correct.
limited partnership,
Yep.
or limited liability
Yep.
partnership, they have a variety of factors that they start looking at. Okay, one of those factors is whether you've kept up with corporate compliance, right?
Okay.
So that's the entire minute book that
Yep.
you do.
Yep.
With corporations, that level of corporate compliance that you have to keep up with is much higher of a standard than with an LLC.
Correct. And that's
Okay.
why LLCs are very popular with small business. And just go back a little bit. What is the corporate veil? Because I think many people that are listening to the show aren't, maybe they don't know what the corporate veil is. So when I say piercing the corporate veil, what does that actually mean in theory, very quickly?
Right. So the whole point of starting a new separate business entity is to separate the legal liability for the operations of the business. So if you want to start up a lemonade stand, right?
Yep.
But you don't want to potentially be liable
Yep.
if it loses money
Yeah.
or some kind of accident negligence caused some kind of damage to somebody else. Then you create this new entity and you let everybody know, hey, when you're buying this lemonade, you're buying it from ABC LLC. You're not buying it from Andrew Easler or James White.
Ah, perfect. Okay. So when we say piercing the corporate veil, that means that they can basically say you are also part of this too, personally, on a personal level.
Right. So let's go back to that lemonade stand.
Yeah.
Right. Let's say I knew that I was using rotten lemons
Yeah.
to make those lemonades.
Yep.
Okay.
Yep.
And I didn't put any money into the LLC to protect it. I didn't buy any insurance for the lemonade stand for the business.
You have no operating agreement.
I have no operating agreement. I've not filed my annual reports. I haven't done my minute book, right? These are all, I'm commingling my funds with the lemonade
Yes.
stand. I went out and bought my own car with it, right? My
yes.
personal
Because
vehicle.
It's a business expense,
Right.
right?
I'm
Yeah.
buying groceries with it.
Yes.
In addition to just
Yeah.
lemons, I'm buying all the other stuff for my own
Yep.
personal use.
Vacations, everything else. Yeah. Soccer
Right.
practice. Yep.
So commingling is one of those other factors. So if I'm basically treating this is the standard. If I'm treating the business as an alter ego
Yep.
of myself, pretty much just for the purpose of trying to separate the liability for
Yep.
sketchy things, right? If I'm
Yep.
frauding people or I'm telling people it's lemonade when it's really not, or I'm using
Correct.
rotten fruit,
Yes.
and I know that it should be it's not fresh,
Yep.
right? Or capable for human consumption, then the court's just going to say, well, obviously this is just a front.
Of
Right.
course.
And it's not fair to the victims of my terrible lemonade
Yes.
to have them have no recourse because I didn't put any money in for them to recover from
And
the
that makes a lot of
damages
sense
or
now.
anything
Now that you're
else.
explaining that, it makes a lot of sense, right?
Right.
So, and that's, I guess, so the must-haves for an LLC operating agreement then obviously would be, define ownership structures,
Hmm.
like basically paying contributions, future contributions, percentages of ownership, etc. Then would be the management of it, right? What about profit and losses? Because I'm thinking, okay, so if I own 50/50,
Mhm.
me and you own 50/50 of an LLC,
Yep.
and the LLC makes X amount of money, and you're just a member, meaning that you're just like a passive type investor, and you believe in me, and I'm the manager, member manager, manager member. Can I decide who gets those profits? So if we have $100,000 net profit, can I pay myself a bonus without you approving that? I guess that would be a rule in the operating agreement. So the operating agreement also outlines, profits and losses and expenses and who gets what, correct? Can you kind of elaborate on that a little bit for me, just so I understand better?
Yeah, absolutely. So when you have an LLC and you have, let's say, 2 or 3 members, who decides what to retain and what to reinvest and how much is coming back to you personally.
Yep.
Well, it's supposed to be something you guys agree on, right? And if you have no operating agreement, then it goes back to Revised Limited Liability Company Act in the state of Florida, for example, and it goes based off of those voting rules. So typically that's majority rules.
Perfect. And that was going to be my next question, which is a good transition, is voting.
Yeah.
So, for instance, in some LLCs that I have, because I have many, because I'm a small business person, I have several small businesses. I have some where people own 50-50. It's a 50-50 partnership, but I have more voting interests.
Right. Or if there's a tie, maybe.
Correct. I'm the tiebreaker.
Yeah,
Correct.
that's something that you could put into your operating agreement.
Because I'm the operator of the business, I have more knowledge on how that business operates. Therefore, I should be able to make the decision, but I also want my business partner to have 50% equity, but I make the decisions ultimately if it's a tie, if we don't agree.
Right. And, what kind of decisions you can make and when you can make them and which stuff requires a vote, which one doesn't. That's all stuff you can put into the operating agreement. It also gives you the option as an LLC to be a member managed LLC versus a manager managed LLC.
Okay, perfect. Can you explain what those two mean?
Yeah. So a member managed LLC is one that's basically governed by the members.
Okay.
And typically each member has equal authority on day-to-day operations of the business. So, let's say you're operating a restaurant.
Yep.
Right. And you want to find a new food vendor. So you go out and you sign a contract with Cisco, right, to give you more food.
Yeah.
Right.
Yeah.
And in a member managed, any of the members could have signed that contract, right?
Oh,
They're
wow.
legally authorized to make that kind of decision as long as it's in the ordinary course of business.
Wow.
Okay.
So that's very important. That's a very important detail because again, if you have that structure and you don't know what your business partner is doing and they start like committing the business to all these crazy things and you're over here saying, oh my God,
Right.
like, what are you doing? You have to, so that's probably thinking about it now. That's probably not a good thing to have two or more unless you're like super close and you have really well-defined roles and responsibilities that
Yeah.
can be in that operating agreement.
Well, I mean, first and foremost, I start sometimes with business
Yeah.
consults, and the person comes up and is like, "I'm looking to start a business, but I want to make sure my operating agreement's on point because I don't trust my partner."
Yep.
Okay.
Yep.
At that point, the question is, if you don't trust them well at this point, and at the outset,
Yes.
why are you going to be starting a business with them?
Correct.
Right.
What's
This is like a marriage, right? You're basically
course.
becoming wed
That's
to your
crazy.
other member.
Yeah.
And if you are having trust issues at this point, maybe you need to rethink the business.
Yeah, and what happens if you have trust issues at the beginning? What happens when money's involved? Because that's generally when problems arise, when there's a lot of money involved and somebody thinks they're getting less or more or whatever the case is, and they start doing funny things. So, okay, so let me recap. So a solid operating agreement is going to have an ownership structure. It's going to define the contributions or the management structure of it, like manager, member managed, or just a member, right?
Yep. I mean, you could have one manager for a manager manage. You could have two managers for two manager manage, and then you got to have an idea of how to break that kind of tie if there's a problem or voting.
Okay, perfect. And then then we have the voting. So it defines, who gets the votes, who doesn't get the votes, who has the voting power, and all that fun
How
stuff.
votes are held,
How votes
how
are
they're
held,
recorded.
meetings, etc. Okay. And then the other thing, which I think is the most personally me, this may not be for everybody else, but for me, it's about what happens when somebody dies, right? Like, so estate planning or planning for succession or something like that. So can you briefly explain how exit rules, like how it can set people up for success when it comes to either like selling the business, buying another business, death of a business partner, and so forth?
Yeah. So by default, if somebody dies without an operating agreement, their interest has to go through probate.
Oh, wow.
Okay. So that's not a fun situation in case you have never done it, especially in the state of Florida. Most estate planning attorneys and probate attorneys charge 3% of the value of the estate
So if you
to
have
conduct
like a
that probate.
house, so if you have a house that's say $300,000, I mean, that's a lot of money.
Right. And it can take years before that interest is resolved. Meanwhile, somebody's got to operate the business.
Correct. And so this is where not having an operating agreement can cause a lot of disruptions, not only to the business, but you can also cause a lot of disruptions for your heirs who
Right.
are supposed to be who you think are supposed to be getting this asset, because by the time they get the asset, it may not be around, but it's also very expensive because if your business is worth $10 million, that's a lot of money.
Right, but it's all based off the $10 million valuation is based off of what net revenue you're having
That's
and
crazy.
how much revenue drop are you
That's
going to have
crazy.
if somebody passes away who's a leader, right?
That's nuts.
So
So you want to avoid vague terms. So what I'm the key takeaway here I'm getting is have an operating agreement from the onset at the very beginning, preferably the day you incorporate the company, and really plan that, or maybe a week after. Like, how does that work? Do you like when would you need the operating agreement?
you want to start that operating agreement before you start operations, right? That's the whole point. You're agreeing on how the operations are
Okay,
supposed to be conducted.
of
Now, you can
course.
go out and file for an articles of
Yeah,
organization,
yeah,
but you should not start operating and utilizing any of the capital that you're putting into the business
yeah.
unless you have an agreement in place
Place
on how
first.
to deal with it, how to operate the internal
So would
governance of
you?
of the business.
So would you do? So I said do it the day of incorporation, right? Because you're not really operating the day of. I maybe you are, right? Maybe you start
Right.
right away. So would you do it? Would you have it signed prior to the official articles of organization being like approved by the state and issued, or would you do it the day of or after? Or does it really matter?
As long as you have an attorney drafting the operating agreement, it doesn't matter.
Oh, really?
Right.
Okay, perfect.
And the operating agreement can say, hey, it's the articles of organization are going to be filed or going to be effective on such and such date.
Ah, that's why you get the
Right.
effective date when you file for. Okay, that makes a lot of sense now. Yeah, I don't want to give people the wrong impression of like filing because I'm not an attorney, right?
Right.
I'm just a person with real world experience that goes out there and does this all the time, and I'm learning every day. So you would generally have the operating agreement like decided upon and most of the terms agreed upon. You'd have it created, and then you would form your company or kind of do it simultaneously.
Yeah. We don't want to put the cart before the horse. The
Yeah.
important thing is that we're
Okay.
not going out there and committing the business to anything or committing yourself to anything until you've ironed out all of the specific terms.
Perfect, because then
Right.
that will complicate creating an operating agreement if you've done a bunch of stuff before you have
Right.
the
You don't want
operating
to be
agreement.
spending $200,000 on a piece of
That makes
equipment
sense.
and
Okay.
you're expecting the other side to put in another $200,000, but they're saying, oh, I only want to commit to 50,
Okay, that makes sense. Yeah,
right?
because that I get that question a lot is, if they don't have an operating agreement, how can I get one done and how do we resolve past actions of the members? Because, some people have really good relationships, right? And they
Right.
trust each other and they never have any problems. They resolve their disputes, right? There's lots of business partners out there that do that. And then there is a dispute or something happens, maybe they pass away and the heir comes in and says, why did you do this? Why did you do that? This wasn't right. This didn't follow the state rules. And
Right.
then now that partner they had a symbiotic relationship. It was all going good.
Handshake deal.
Handshake deals, and all of a sudden they're dealing with like a crazy ex-wife or a crazy, stepchild or something like that. And it just ruins not only the experience, but the business and that friendship or that those people
Yeah,
had,
that's not
right?
to say that
Yeah.
obviously people that come into the business as an heir can't be a good business partner.
Yeah.
But the problem is if you don't have the terms of your membership agreement and your arrangement in reduced to writing, then that new person that comes in is going to look at the
Yeah.
situation on the
Yeah.
basis of what the default is, which is the statute. And so
Yeah.
they're going to come in and say, okay, well, there's no operating agreement, which means if dad and his business partner were on Sunbiz or Secretary of State
Yeah.
website
Yeah.
as members together,
Yeah.
there's 50-50. Meanwhile, you and your business partner had made a deal that it was going to
Wow.
be 90-10,
Yeah.
right?
Yeah.
And now there's a dispute. And oh my gosh, you've gotten 40% more profit over the last 4 years. My dad had no idea that you were stealing this 40% profit,
Wow.
on
Yeah.
over this stuff, even though it wasn't really him stealing,
It was
that
an
was the
agreement. They had a
arrangement.
handshake
And now
agreement.
this
Yeah.
person has to try and prove in
Yeah.
court, for example,
Yes.
that wasn't the arrangement.
And that's hard to do without writing, especially if you do handshake type deals, right?
Right. And the other witness is now no longer available.
So I guess no vague terms. Speak with an attorney and your business partner. If it's just you, figure out what you want to accomplish in your goals, and maybe have a consultation and figure it out from there by answering questions and getting some answers back. Now, my next question about an operating agreement. So, okay, we have an operating agreement. We're good to go. We have all of our terms and conditions and everything ironed out. We're signed it. Do you have to update an operating agreement? I would assume, based on my experience, you should update it or look at it occasionally and say, hey, we need to update this and change this. So how often, well, should you update it? Yes, I think the answer, I think we can say is yes.
Yeah,
Right?
I want to give you an example.
Okay, go ahead. Give me an
In
example.
December, there was a court case that came out of Arizona.
Yep.
Right. And just so everyone else is aware, right? Limited liability companies, they use pretty much a standardized act across the
Okay.
United States. If there's a state that says, I want to start doing LLCs,
Yeah.
they will pretty much copy what the other states have done.
Okay.
Okay.
And it's December 2024.
2024,
Okay.
December of
Perfect.
2024,
Okay. Perfect.
this case came out.
Okay.
And what it said basically was, if you have a silent partner
Yeah.
in an LLC, their creditors in a bankruptcy can come and stand in their shoes
Oh,
and
wow.
essentially take their shares just like they would take the shares of Apple in their investment
Oh, wow.
portfolio.
Okay.
Okay.
Yeah.
And that is something that us business attorneys have probably never seen before or even expected that decision to come into play,
Oh,
right?
wow.
So that is something that now people like me are amending operating agreements for all the time, right? Because we want to make sure that our clients understand either the risk of being a silent partner in a membership an LLC, or whether they really don't want to be a silent partner anymore and want to be materially active and have a material obligation to the business, and therefore their creditors can't come in and step in their shoes and take away their membership
Wow.
interest
So
as a severable
there's
part.
probably many people that just did a DIY operating agreement, have never had any issues they don't really understand or know. And then there's the people that have had them
Right.
prepared by attorneys or, somebody else maybe. And they're not up to date and the most current. So they're actually exposing themselves to more liability. So I guess the key takeaway for this would be, like, how often would you review the operating agreement? Like once a year? Do you think that's fair? Once every 6 months? I mean, obviously you should know your operating agreement. If you have one, you should study it, research it, and fully understand it. But
Right.
I'm a small business guy. I'm going to be realistic. I once I get it done, I just start making money, right? And I think most people are like me. So for me, would it be like, what would you suggest? Like every 6 months, every year?
Yeah, so let's talk about that for a second. So, when we start the operating agreement, the idea is that we think about the possible problem scenarios that potentially would ever
Yeah,
occur in the future
yeah,
and put them into paper. And then what happens is we put it into a book
yep,
and then forget about it and it
yep.
collects dust until that dispute starts
Correct. And then you open it
starts
up, you're like,
rearing
oh
its
my
head.
God, oh my
I'm so
God. Like,
glad we planned for this, or
yes,
wow, I can't believe we didn't put this in the operating agreement on
yeah,
what we should do in this scenario,
shocks.
right?
Yes,
So
yes.
definitely, you should have an attorney review your operating agreement at least every couple of years to make sure you're keeping up with the changes in either the statutes or case law as they continue to reinterpret how things are
And
supposed to
also your
work.
business operations, because they may change over time, right?
Right.
So, you may bring on another member and the other member may leave or there might be death or
Right. Just
anything.
last week, I was reviewing an operating agreement for some people who had another attorney draft it. And I asked them about a specific provision, and they said, no, we thought it meant the opposite.
Yeah.
And they had basically got their attorney to draft this provision that was completely the opposite of what they wanted.
And that's why it's so important to fully understand and ask an attorney questions on what this means and how it works related to your business, right? So if I
Right.
have a business, I'm going to ask you, okay, I see this provision here, the transfer on death provision or whatever you want to call it. And what does this actually mean? So if I die, it goes here, but what happens after I die? And so if you have questions, continue to ask questions to make sure you fully understand what that term means. Because sometimes because we're experienced in business and we've done a lot of different, um, different projects together or, we kind of assume, right? And I think that's the biggest problem is people assuming. So me personally, what I do or what I think I'm going to start doing is when I file my annual return once a year, I'm just going to give it a quick read, right? At my annual meeting, if I have partners, and just give it a quick read and say, does this represent our current operating procedures? Is this what we want? Have you changed? Like, here's an example.
Hmm.
I have two partners, right? And one partner just updated their estate plan. They got into a fight with their child and they updated their estate plan and didn't want that membership interest going to that one specific child, right?
Hmm.
And so we were just talking and this came up. This is a real thing. This came up and all of a sudden, they said, oh, I don't want my child to get this, a membership interest. And I said, well, in our operating agreement, it says that your child gets this membership
Right.
interest. So in that aspect, when I came to you and we had this discussion, does the operating agreement supersede an estate plan? Meaning that if I have a friend that changed the ownership and said, hey, I don't want my daughter to get this, but in the operating agreement it says that the daughter, this child, that the son gets this, what prevails?
Yeah, great question. So, as long as the operating agreement is clear and it
Yeah.
specifically identifies an individual who
Yeah.
is then in existence,
Yep.
right? They haven't passed away previously,
Yep.
right? And is able to take that interest,
Yep.
then the operating agreement is going to control because it's
Oh,
under
wow.
contract law, just like a life insurance policy,
Wow. So
right?
that's why it's so important to always review your operating agreement. Or if you have a small business yourself and you don't have an operating agreement, that could potentially be a backup for an estate plan that gone wrong.
Correct. Yeah. I mean, everybody that I create an LLC for, I always try and get them to name individual beneficiaries or their
Yes.
trust, for
That's very
example,
smart. Yes.
in the operating agreement to avoid probate. Because
Wow.
again, even if you have a will in place, it's not going to avoid probate necessarily.
Wow. So an operating agreement can not only prevent disputes, it can outline, roles and responsibilities, contributions, who has voting power, and then also it can help with estate planning, specifically maybe avoiding probate
Right.
if done correctly, right? And it
Yeah.
also provides an element of asset protection, especially when we were talking about earlier. It was tenants by the entireties.
Yeah, tenants by
Tenants
the
by
entirety
entireties.
is a relationship that
Okay.
husband and wife can hold the interest together, and that's going
Okay.
to help protect them from certain creditors that come after them individually.
Yep.
And then another benefit is multi-member LLCs in the state of Florida. We have protection against charging orders under
Yep.
the underlying assets of the LLC if you're a multi-member LLC.
Oh wow.
And then, of course, the operating agreement it can also indemnify managers and officers of the business. There can be a variety of different things that we can
So
add into the operating
And
agreement.
this is why I think it's so important to actually hire a professional to do and to like help you create and write and edit your operating agreement, because I feel like using templates myself before, even though I think they were like I don't know, a couple $100, and then I ended up hiring before I met you. I hired an attorney, and it was like $1,000 or something. I think it was $800, maybe 1,000, and I was so appreciative of that time because for the extra $500 or 600, whatever it costs, you're getting so much more value, and you actually have somebody to fall back on. So if you do have a question later on, like say a year after making your operating agreement,
Right.
and maybe you're not clear, you don't understand, or maybe you forgot, you can call that person up and say, hey, what does this actually mean? Whereas if you like DIY it, you're like, I think this is what it means, but I really don't know. And I'm not an attorney and I don't have a lot of legal experience because maybe I have a landscaping company or a construction company. And I'm just trusting that everything's going to be okay,
Right.
even though it's not. And then all of a sudden, when things happen, you're trying to create, fix or resolve a mess that is very difficult to resolve. So you actually spend more money long term trying to resolve issues by having an incomplete or incompatible operating agreement for what your business purpose or use is.
Yeah, I mean that was a great explanation, and I just want to emphasize, just like people encourage you to ask questions of your doctor,
Yes.
ask questions of your attorney, right?
Yes.
We held a degree called the Juris Doctor,
Yes.
right? In Latin, that means the teacher of laws. Our job is to teach you, as
Yeah.
our job is to obviously do what's in your best interest. But most of the time, that's in business. That's having you guys understand what you're signing,
Yeah.
right?
Yeah.
I'm not doing you any favors by having you sign a piece of paper that you don't understand.
Correct. And that's the goal. And I think that's what creates a really successful lawyer, like or an attorney. And when we met about 15 years ago and you decided to become an attorney, because we had, interesting experiences, right?
Right.
Um, that's something that, was a big priority for us, right? We wanted to do it right.
Yeah, I mean, of course, there's a full spectrum on that, right? You don't
Yeah.
want to be the person that thinks they know better than the lawyer,
Yeah. Of
right?
course. Of course.
But you also want to make sure that you really understand what you're getting yourself into. And
Yeah.
if you don't feel confident, you're not liking the answers that you're getting from your attorney, ask somebody else,
Yeah,
right? Get a second
It's
opinion.
always okay to get a second opinion. And maybe, I have some friends that are, have medium-sized businesses and they have multiple attorneys.
Yeah,
And what they do is they get, two or three of their attorneys on the phone and they have a little conference call and they all hash it out and decide what, position to follow or what to do. Now, for an operating agreement, I think you don't need like a whole, team of attorneys to review it unless you
right.
have a serious estate plan or you have a large asset or something where you really want to be sure. So I think one attorney for an operating agreement is probably sufficient.
Yeah, as long as they're a business attorney.
Correct.
Yeah,
And as long, yeah. So I think that is probably very reasonable. And I would assume, obviously we're in 2025, the beginning of 2025, we're definitely having some economic challenges here. So, Based on my experience doing some price setting, I'm looking at, a personalized attorney prepared operating agreement. I would assume like under $1,000 or probably around that range. But it can be up or more just depending on the attorney. Like if you're in South Florida, it might be much more than say Northern Florida, where they're a small town. There's like one or two attorneys that are more reasonable, right?
Yeah, absolutely. So Miami is a totally different market in the state of
Yes,
Florida for anybody
yes.
that's not
We
from
don't we
Florida.
don't talk about Miami very often because it's a very interesting city when it comes to legal and
It
all
is.
that
It's
fun
a whole
stuff.
different world.
Yes, they
And
should be like a
and
separate
they
state,
a
really.
lot of those practitioners don't like
Yes.
coming up. We
Yes.
don't like going down.
Yes, it's kind of
So,
a old little. There you go. People got the secret to Florida, right?
but
Secret
no,
Florida attorneys.
in all seriousness,
Yeah.
less than $1,000 is very common for an
Okay.
LLC operating agreement. Of course, there's going to be a spectrum, right? If you're asking for a million custom provisions,
Then it might be more. I'm
then
just
of course,
talking like the for a small business, the basic, the basics where you have some Q&A with an attorney, you have a consultation, you have the back and forth, the explanations and so forth. I think that's probably a reasonable price to expect to pay. But
yeah,
again, it could be more. Like we've in my personal experience, dealing with some friends, just talking to them, and just talking to them about business succession and stuff like that. I mean, their operating agreements are very comprehensive because they have major assets, they have major corporate structures, they have different ownership types as part of their larger estate plan. So again, you can ask an attorney up front, I guess, if you're nervous, because I think a lot of people get nervous that an operating agreement is going to cost them a lot of money, even though
right.
it's not as much as people think they're going to pay. Just obviously, talk to your attorney, say, hey, how much is your operating agreement? Is it flat fee? Do you charge hourly? And if you charge flat fee, is there going to be an additional charge later on if I need to make changes and so forth? So just be open with your attorney and say, hey, this is my personal advice, by the way, for anybody listening. Talk to your attorney, be open with that attorney, and just ask them for a price quote. And again, if you're the royal family and you have like all these crazy, corporate structures, yeah, you could get into thousands of dollars. But for the average person, I think budgeting around $1,000 or maybe less would probably be sufficient for them to get a properly done operating agreement
Yeah.
prepared.
And when you're calling around, let's say you're calling an attorney,
Yeah.
of course, price should not be your number one.
Of course,
Deciding
well,
on,
yeah, but you
on
gotta
an
be
attorney,
realistic. I mean,
look at
small
the
businesses.
reviews, look at,
Yeah, of course.
maybe get referrals, that kind of stuff.
Of course.
But if you're asking, right, you
Yeah.
should be able to call up and say, hey, what's the range of
A range.
costs
I like
here?
that. Okay,
Right?
so
They're usually not going to want to most attorneys and law firms don't want to pinpoint an actual amount in case you
yeah,
come in with a
yeah, of
million
course,
complicated provisions you want to
of
add in there.
course.
But they can usually give you a range. And if they're not willing to give you a range, it's a little bit of a concern. Either they don't normally do it very often,
Yeah.
or it's something that they charge a lot for.
So what I do, what I do when I work with an attorney, or I'm thinking about doing something, is I will book a consultation. I'll speak with that attorney to kind of make sure we're a good match, make sure we have a good energy,
Right.
good connection. Because if you don't feel comfortable with whether it's a doctor, attorney, or anybody, a vendor, I mean, you're not going to have a great relationship if you don't feel open and comfortable.
Right.
So what I generally, whether it's an attorney, an accountant, CPA, I will pay for a consultation. I will try and explain what I'm trying to accomplish, and then I'll ask for pricing afterwards so they have a better idea of what we're doing and everybody has the same expectations, right? Because nobody likes a surprise bill.
100%.
I'm a small business owner too, I'm in this space, but I still don't like surprise bills.
Yeah, I
So
mean, if my client is surprised,
yeah,
then I have not done my job.
of course, it's
Right?
communication, right? Your job is
My
to
job is to
communicate.
set expectations
Yes.
and do what's in the best interest of my
Yes.
clients.
Perfect. So
Right.
if it was my choice, I'd obviously hire an attorney to do an operating agreement. I would not do it yourself or use online templates because, as you discussed earlier, in December 24 with the new case precedent, and where was it out of again?
Arizona.
Arizona, yeah. A form or a template online that is not personalized to the person that has the LLC. If rules change over time, that LLC operating agreement may be null and void, or there may be complications later on when you're trying to enforce certain provisions.
Right, absolutely.
Yeah, that makes a lot of
Or
sense.
when one of your members goes broke.
And it's private, right? So you could have the cupcake, which is your LLC. You put
Mhm.
whatever sprinkles and decorations you want on top. That's your operating agreement. And you don't have to file it publicly with anybody, obviously, because it's private.
Right.
Would you ever suggest like giving a copy of the agreement to like your children or maybe like a banker or something, especially if you have like succession planning or some sort of asset protection planning, if you pass away, where it goes to, just so everybody's on the same page? Or would you keep it quiet and just personal And then if something happens, then they can present that operating agreement.
Yeah, so at the very minimum, you want to have your attorney have a copy of your
Yeah, of
operating
course. Yeah,
agreement,
that makes
and then
sense.
you keep
Yes.
your own copy.
Okay, perfect.
You can keep it with your estate plan because as long as you have the right provisions in there, it is going to be part of your estate plan,
That's very
right?
okay.
So
Yep.
whoever you name
Yep.
to be your personal representative,
Yep.
as we call them in the state of Florida, most people
Yep.
know them as executors or executrix.
Yep.
You can let them know or where it's going to be found. You can put it in a safe, whatever it is,
Okay.
and say, hey, if I pass away, go here.
Yeah.
So that's another good strategy
Okay.
for that.
So we have the operating agreement done. Now, question, I've always wondered this actually personally. So if I have an operating agreement and it's private, how do I prove that I actually have the operating agreement at the time that I actually said I had it and not like some random place? So if I get in trouble and I don't have an operating agreement and I just quickly make one and sign it, how do they prove that I didn't have it to begin with? Does that make sense? Like, so for me, when I do an operating agreement, I always make sure I e-sign it because I like the time and date stamp because nobody can ever say I didn't do it at that specific date and time or like notarize it. Like what I do, and I know I don't think this is required,
No.
but what I like to do, because I'm extra special, right? If I have partners, I actually get it notarized. I
Right.
go sign it. I make sure everybody's aware of it, and I get it all notarized. So if there's any issues later on, I have a time and date or a time stamp or date stamp, and then I have a verified signature, so nobody can dispute the fact that they didn't sign it or it wasn't done at a specific date and time.
Yeah. So, it definitely electronic signatures using something like Adobe Sign or eSign, that kind of stuff.
Yeah.
That's going to have what we call legally attribution,
Yeah.
which is going to be those time and date and where
Perfect.
it was, IP addresses, those
Yes.
kinds of things,
Yes.
to track it
Yep.
and prove the timing. Now, of course, any contract could be subject to forgery, fraud, or anything else.
Yeah.
So it's going to be based off of the individual circumstances of that case.
Of course.
So it's easier if you have attribution, for example,
Yes.
or a notary stamp
Yep.
to prove that. But it doesn't necessarily mean that if you don't have those things, that you're not going to be able to prove that the
Enforce it.
contract was in existence at that particular
Yeah, and
time.
I'm always a little extra. Even the resolutions I do, I get everything notarized. I think that's for me, it's a good habit. So again, that's just my personal prerogative, right? It's not required, but I like to do it anyways. So I just have that attribution on my paperwork.
You've got that trust but verify
Yes,
attitude.
trust but verify. So I think that's pretty much it for an operating agreement. Is there any other thing you could maybe like tips or tricks you can give somebody that is thinking about reviewing their current operating agreement, or they don't have one and they want to establish one? Actually, wait. My next question that I have now that I said that was, okay, so I have a business. I've started a business. I've been operating it for months, years, whatever.
Right.
I've never had an operating agreement. It's just me that owns it. I manage it, whatever. I'm a landscaper. I don't really see the need for it. I've never had to have a need for it. How do you deal with, as an attorney, if somebody comes in and speaks with you about that, how do you deal with the prior actions? Would you just do like a clause in there that says all prior actions are blah, 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 if it's just them? Does that make sense?
Okay, so we've got a sole member LLC that's been
Yeah.
operating for, let's
Yeah.
say, 6 years on its own.
Yeah,
No operating agreement,
correct.
right? Just articles of organizations that have been filed.
Correct.
If they have a bank account, they would have had to do usually a resolution to open the bank account. So I'd want
Okay.
to see where that is.
Yeah.
Right. And we want to have a minute book put together.
Okay.
Generally, you want to have annual meetings. So you want to have minutes for that. But it's not required under
Yeah.
the statute. So really, you just start from scratch with an operating agreement. Make sure that you're addressing all of the needs of that person. In particular, for a sole member LLC, I would focus a lot on the succession planning aspect of it.
Correct.
Right? Are you married? Do you want it to go to your spouse? Who do you want it to go to? Do you already have an existing estate plan? Do
Yeah.
you have a trust?
Yeah.
And what's going to happen to this business once you pass away?
Wow. Yeah. So you don't need. So if somebody 6 years from now comes back and says, "I've never had an operating agreement. I need one done now for whatever reason. I'm just thinking about my estate planning. I'm thinking about expanding my business, and the SBA wants a copy of it or whatever."
Right.
You could do one at that time and then retroactively kind of work your way backwards for any major decisions, and then take care of those decisions at the same time.
Well, I mean, I'm not sure what kind of major decisions you would be referring to.
Yeah.
If you're a sole member, then you
Yeah.
pretty much have full discretion to
Okay.
sign contracts,
Okay.
obligate the
Perfect.
business. I think
Okay.
it's probably going to be a little more concerning when you have another member, right? If you're not a sole member LLC and you start out there and you have multi-member LLCs and you've done a whole bunch of stuff in the
Yeah.
past,
Yeah.
that's where we got to go back and say, okay, we did X, Y, and Z. Y and Z, we should have had a vote on, for example.
Correct. That's what I
Right.
was.
But we didn't.
Yeah, that's the whole point I was trying to make.
So,
Is if you have, so say if you have two people in an LLC
right.
and they've never done an operating room because they just never knew or they just didn't feel the need for it at the time, and they come back to you or they come to you, for instance, and say,
Right.
"Hey, we have a company, an LLC. We've made all these decisions. How would an attorney handle that, or how would that situation be handled if they didn't have an operating agreement? They were partners, and they come to you like 5 years later or something like that, and want to do an operating agreement for whatever reason.
Mhm.
How would you handle all those decisions that were made from the time of organization, to the time that they seen you?
Well, we want to look at any of the major decisions that were made outside of the ordinary course of business, right? And without knowing more about their business, we
Yeah.
wouldn't really know what's in the course of the ordinary course of business and what is. But those things that are outside of the ordinary course of business, we want to make sure that we crystallize those decisions, right?
Yeah.
So that both members can write on a piece of paper that they were okay with the decision, that it wasn't done just by one of the members on their own,
Yeah.
going rogue,
Yeah.
right? And, suddenly binding the company and then potentially breaching their fiduciary duty. So we want to
Got you.
identify all of
Yep.
those decisions that were outside of the ordinary course of business and make sure that they're acknowledged either directly in the operating agreement or by a separate resolution. The other thing you want to do is when you're reviewing that operating agreement is to make sure that they haven't done too many things that have started ticking the boxes on piercing of the corporate veil analysis that we
Correct.
talked about earlier.
Yes, and that's
Right?
another show that we're going to have, I think, later on, because I think that's a really interesting topic that almost 95% of small business people have no idea about, and they don't understand how catastrophic that could be if you don't manage your business right.
Right.
So yeah, we can get into another. That's another show. That's going to be a good show, actually. I think that's going to be a fun show.
Yeah.
So to wrap things up here, I think the key takeaways for me are always hire an attorney prior to forming your articles or filing the articles of organization.
Yeah, you'd be surprised how many people have come to me for a consultation and said, I want to, form this corporation and I want to do this, this, and this. And by the time they walk out, they've got a completely different plan or they're not going to form the business at all.
Wow, because they realize that wow. I mean, that's cool. So, okay, hire an attorney, obviously. Do not do it yourself. I don't recommend it personally. Always start with an operating agreement. So don't wait. So try and have that operating agreement done before
Before you start any
before you
operations.
start any operations. And then once you have that operating agreement done, make sure you review it, like I would say, every year. Personally, I do mine every year. I just quickly read it so I understand it. I mean, I understand all my operating agreements if I have one, but I like to review it every year on my annual return date. That way it reminds me to do it.
Mhm.
And then make sure it addresses, estate planning and succession planning and voting rights and contributions and who gets what, because there could be 50%, 50-50, but the profits and losses may also be like 60-40. So each person may own 50-50, but then one person, the manager, may get more of a distribution than the other one because they're managing the business. And that's what that operating agreement will outline. Correct?
Yeah. So compensation, distribution, whether you get a salary, whether
Yeah.
you don't get a salary,
Mhm.
how much a pro rata share of the profits
Yeah.
and losses you get,
Yep.
voting rights, all of those crazy things.
Yep.
Even if you verbally agree on it, you really want it and you need it reduced to writing.
Perfect. Well, we're done for the show today. Thank you very much.
Hey, thanks for listening to us. I hope it was as fun as it was for me, as it was for you.
Yes, and make sure, again, if you have any questions, obviously we're not providing legal advice. All this is for educational purposes only. If you have any suggestions for us to improve what we're doing, that'd be great. Just comment below. Make sure you not put any, what do they call that?
Privileged and confidential information.
Privileged and confidential information, because that is not protected by any means, and it's accessible for everybody. So make sure you keep it general and generic. And again, if you need personalized legal advice, always contact an attorney. There's a lot of good ones out there that do want to help you. And again, don't be afraid to ask them questions, right?
Yeah.
Okay, perfect. Well, that wraps up for episode number 2. We're going. Awesome. Thanks, everybody.
Have a good one.